Welcome to Antitrust Code by Concurrences. Concurrences is the leading antitrust database with over 40,000 articles on competition law. Concurrences is also the largest network of antitrust experts, with lawyers, economists, enforcers, and academics in 85 countries. By listening to this podcast, you will learn the fundamentals of competition law and hear about the latest antitrust news. Thanks to our guests, the best experts in the antitrust world.
Hello, everyone. Thank you for watching this today. Hopefully, it's going to be informative about the innovation paradox in merger control book that I wrote, and Professor Frédéric Jenny was so kind to also provide a forward to. Now I am with him, and this topic is very dear to our hearts, the topic being innovation considerations in merger control. I was very privileged and honored that he found that this book of mine has added something new into this debate, which is not an easy feat, especially when it is his eyes reviewing the matter. And what I tried to do in the Innovation Paradox in Merger Control book that is published by Concurrences was to both provide the underpinnings of the concept of innovation and how it evolved into its perception of today, why it is critical from an economic growth perspective, why it could be considered the true engine of economic growth, and therefore it's linked with dynamic efficiencies, and then a dive into all of the cases in the EU and vis-a-vis the CMA in the UK and the FTC and the Department of Justice in the United States that are discussing any element of innovation, basically. Some of them are paying lip service to innovation. There is talk of innovation, but it's not really a discussion of innovation that will be germane to the ultimate outcome of the case that they have at hand. Still, it is covered. And some of them are putting right in the center of their attention the concept of innovation, typically with fear, with concerns that innovation might be negatively impacted if the concentration at hand were to be allowed. So now today we're going to have a conversation with Fred, who needs no introduction, but still I will give a different type of introduction. Frédéric Jenny is probably one of the top academics, judges, and also regulators by way of background in the world. He has been at all sides of the table. He has been extremely influential, not only in the shaping of practice in France, but also in a lot of markets, including quite a bit of developing markets. He certainly has not been shy in traveling around the world for competition law purposes, which means he has been spreading the word, his word, and also the word of reason for a very, very long time. With that intro, I'd like to turn it over to Fred. I think the format is going to be that he's questioning me a bit as well, but I asked his patience in me asking him questions or asking for his opinion on the same question as well, because he has been through and through reading the book and he knows where its shortcomings are or what the fundamental thesis that he might not be agreeing with. But most importantly, he is the lead figure in this particular field, so it would be a pity for me to turn this into a shameless advertisement of the book only while we have him. So over to you, Fred.
Well, thank you very much, Gönenç, for inviting me to discuss your book, The Innovation Paradox in Merger Control. And this is a book that I was very interested in reading, A, because I think innovation is indeed important, as you say, and B, because it's a very thorough analysis of the issues, and in particular, as you mentioned, the studying of more than 70 cases which have been dealt with by the competition authorities in the US, the UK, and the EU is very informative and leads to very interesting questions. So I would like to start maybe my questioning by asking you one question. You observe in your book the fact that for a long time, in fact, competition authorities have not been all that interested in the issue of innovation. But you also remark that, and this is the reason for the book, in fact, the fact that innovation has become front and center in many economic analysis or competition analysis. And I wanted to ask you, why do you think that there's this move towards taking more into consideration innovation than used to be the case? Is it that the goals of competition laws have changed? Is it that the mood of governments have changed? I mean, what do you attribute this new interest for innovation to?
I think part of it is the markets moving in that direction. So when I started practicing competition law some 25 years ago, which is not an impressive figure for you, it was more your ready mixed concrete producer and the cement manufacturers and bread yeast and, real industry, dye stuffs, what have you. And the markets have evolved into the digital sphere so significantly that competition authorities had to harbor new ideas of evolution of markets. So I think while the conversation that competition should be looked at not as a snapshot, but as a process is not a new conversation, and it has been around for definitely more than 25 years. The actual practice of it has come a bit late. And competition authorities themselves have started realizing that there is an evolution, and that evolution needs to be protected going into the future as well. And a large part of it is the innovation process, the innovation motivation in the markets. Dynamic efficiencies have been discussed for a very long time. I remember writing another book and publishing it back in 2001. The Turkish Competition Authority had published it. And the name of the book was from a law and economics perspective, the prime objective of competition law. And I remember devoting a large chunk of time and energy on dynamic efficiencies being the particularly important locomotive in cost efficiencies, allocative efficiencies, dynamic efficiencies, kind of a triage. And there was good authority from a doctrinal perspective. So people were not overlooking dynamic efficiencies when it came to the theory. But I think in practice, it kicked in with the markets moving into that direction. Not only the digital markets, pharma markets as well, and what have you. And some cases have presented a low-hanging fruit as well, because some pharma cases have FDA approval processes and, phase 1 development, phase 2 development, phase 3 development. So you have a very clear pipeline. And as an antitrust authority, you really can prima facie take a dive into what is going to happen in the future in terms of product development. That has also, I think, inspired competition agencies quite a bit in at least hitting bullseye in enforcement in these spheres. And then it became contagious to some other markets. We have seen it in McDonnell Douglas. Boeing matter actually was quite pleasant because there was competition capacity being discussed there as well. Maybe a vague attempt to also discuss it in Dow DuPont, but I think Dow DuPont in general is a disastrous case for reasons discussed in the Innovation Paradox and Merger Control book. But a short version of the answer is, I think the evolution of the markets has demanded that competition authorities find a new appetite for what has been under their nose, what they have been paying some tribute to, but what was not moving into the center of their attention.
Now, one of the things that you mentioned at the same time is the fact that competition authorities have been, I'm not sure that you used the word, but that's the idea, have been dismissing out of hand dynamic efficiencies. But how does that fit with what you just said, which is the fact that they have become convinced that this is an important issue that they should look at?
It marries into this conversation in the following way, and this is the paradoxical bit. that gives a bit of a name to the book as well. When it comes to articulating a concern, when it comes to defending competition as such, competition authorities have been quick to embrace the existence of dynamic efficiencies and have been quick to assume that it's quite fragile too. But when it comes to allowing defense counsel to run with arguments of dynamic efficiency, to run with certain arguments that make it not a point of concern, but rather a shield or in favor of the transaction at hand, then competition authorities have been quick to dismiss it as not articulable, not calculable. This is narratives only. Whereas in a lot of the cases where competition authorities build their own theory of harm on innovation, you still see only references to general economic literature, sometimes a bit more innovation-specific literature, a lot of scaremongering, but very little articulable and direct language on how that harm comes about. There is a speculative nature there, so it should have been understandable that there will have to be a speculative nature in the defense too. In fact, and this is something I'm also discussing in the book, if anyone should be allowed to be a bit more speculative in this field, probably one should give the benefit of the doubt to the defense counsel or the parties representing the transaction before the authorities, because they only have the data of the applicant parties. And typically, the discussion on innovation effects require all of the stakeholders' data in that relevant market and a capturing of the entire ecosystem and what's going on. So if we don't have competition authorities that truly have a genuine appetite to capture innovation effects, it is quite easy and convenient to be dismissive. But as the book also discusses then, what happens is that you end up engaging in perverse enforcement from time to time, and you go into type 1 headers, type 2 headers very easily, because it is true that innovation as a concept is a bit mystical, which means it can harbor certain worries very easily, or it can be hijacked to any direction.
There is a notion that competition authorities have pushed, the fact that the parties themselves in cases don't bring very convincing cases about innovation or about dynamic efficiencies. So what they would say is that we don't dismiss it out of hand. It's just that either the argument is not presented, or if it's presented, it is very summarily presented. And indeed, if I'm not mistaken, in your sampling of cases, in the 70 or so cases that you look at, I think that you said that in a third of the cases, there were no issue of innovation. In your sense, was it because there were no innovations involved, or was it because there was reticence to bring those issues, presumably because the competition authorities were not giving them the weight that they deserved?
It could be either the latter. So I'm not excluding the possibility that there may be counsel error in some of these as well. If we're going to criticize competition agencies for not capturing innovation right, I think we cannot suddenly assume that all lawyers are fully aware of how to get the data from the client, how to understand that there is an innovation angle. The minute you go in with your memorized patterns of dealing with a merger control filing, actually you exclude innovation concerns unless there's someone at the client side who knows that this is relevant and who is really keen on flagging it. So probing it, milking it, understanding, milking in the sense that, getting the raw material from the client and understanding the true dimensions of the innovation matter in the case at hand is already a bit of a difficult matter, and one has to think outside the box. Not all counsel do that. But even in those instances where they wake up to the fact that there is an innovation angle in this, there may be a strategic call to not invoke it. I know that I'm guilty of this from time to time as well, because it does get, as I said, hijacked from time to time. and going in, you make an innovation point, and suddenly it gets recycled and processed in such a way that you have opened a whole new front of line of questioning, basically. So unless it's a very slam dunk innovation point, the same standards of proof murkiness is leading to the defense counsel sitting on innovation arguments. Because defense counsel thinks this has happened a lot in the ecosystems discussion as well. Digital platforms came up with the ecosystems vocabulary, and they were the ones that taught all of us as defense counsel and all of the antitrust regulators the existence of such a thing as an ecosystem, and how it may be impacted and everything. And ultimately, where we ended up was competition agencies suddenly coming up with completely different theories of harm on the ecosystem. So they picked the ball and ran with it in such a way that the defense counsel that introduced these arguments felt net they may have gained 2 units of ground, and they have opened up 500 fronts of ecosystem inquiries. So innovation is prone to becoming that animal in the absence of 2 things that I argue in favor of in the book. One, a neutral starting point of review when innovation is going to be looked at, so no presumptions. And 2, a case-specific articulation of a theory of harm, if there is going to be one, on innovation that is backed with a case-specific economic analysis that is making it clear that there is something here. In the absence of that, I think parties are going to feel, ours is going to be discounted anyway as a defense because it won't be found concrete enough. And yet we will have inspired them. And once they hold the mic, they get to sing whatever they want to sing. So let's not get into this debate altogether. That's, I think, happening quite a bit.
So it's very dangerous for defense counsel to innovate.
It is, and it is also very dangerous for, I think, the overall competition law enforcement, in the sense that then you're not getting the input that you should be getting as the enforcer.
But let me ask you something. One of the assumptions in your book is that competition authorities could do a better job, and you've mentioned this. They should be more neutral, but that assumes that there is such a thing as an intellectual framework relating innovation to competition. One of the questions which is being debated is whether economic analysis, and in particular macroeconomic analysis, gives us such a framework, or whether there is a lack of understanding by economists, really, of the complex relationship between competition and innovation. There's a very simple kind of macroeconomic view that competition must be good for innovation. But when you go into detail of why it is good, or in which cases is it good and in which cases might it slow down innovation, you get, from the theoretical point of view, a very murky set of considerations by economists. And you have Schumpeter on one side, you have Arrow on the other side, you have people in between, like Aguillon. So my question is, are you asking competition authorities to do something that they are unfit to do because they don't have the framework to do it?
This is a spectacular question, and one that I leave open in the book purposefully, and then one I'm trying to now bridge the gap to. I had gotten to this in the book, and there was a chapter. Then it turned into a mess, that chapter, and I felt this is going to delay the book so significantly. And I was also tired of constantly updating the book, because it's like painting a moving train, on this kind of a topic. Just at the point in time when you're about to publish it, Microsoft Activision happens. So you withdraw it and you update it. Just when you're sending it Illumina Grail, that happens. So at some point, I parked this particular question. So what is the economical framework that would be more preferable? The principles are in there. What needs to be done in my thesis is in there. But now I have an article that is about to be published, written together with David Teeth. where the two of us are arguing that there should be a bit more use of the tools of the business administration side and more of complexity economics work as well, without any disrespect to the RBBs and micras and whatnots of the world that do competition economics in a certain way, because it has been done in a certain way for such a long time. There is a lack of innovation in that sphere as well, it seems. And this has to come in with Defense Council's push. I don't think competition agencies would dive into it at their own volition. This needs to be shown to the authorities. And it's not only the literature itself. It's not about, photocopying a few pages from one of those articles and, annexing it, but rather the idea that there is a whole discipline that is working on the mysterious creature that is innovation. There is a whole literature dedicated to the relationship between innovation and R&D activities and what kind of an actual structure we're looking at, depending on what market you're in. And a better understanding of this by the antitrust regulators will allow for a better tailor-made kind of approach into these matters. So at the moment, a lot of regulators are still treating it as if there is a linear relationship, a pipeline, and from one end you feed the R&D, and at some point you get some innovation from the other end of the pipeline. Whereas this is a very zigzaggy matter. You fail a lot. There are a lot of companies that set sail on innovation, and because the innovation doesn't come in with the timeline that they hoped, they go bankrupt and all that. We exclude all of this from all of our analyses, and we do a hindsight kind of analysis. This happens a lot. People look, and I don't intend to discuss that transaction here, but just to give an example, people look at Meta WhatsApp, and in conferences today, a lot of people academically say, well, that should not have been allowed, or at least not that easily. And a lot of people nod in the audience. But back in the day, we were all there when this was being proposed as a transaction. And the monetization was obscure, and a lot of these kinds of transactions have failed too. So holistically, one needs to look into this, and holistically, one needs to capture how can we protect the innovation with its dynamics in this market. This is a very important point close to your heart too. I know we have spoken with you on this topic in Paris last year. And this requires a look particularly into innovation capacity as a concept as well. Because if we don't get enough understanding of what the innovation capacity is, which is a case-specific analysis, then really all we discuss is how motivation for innovation could be impacted. I'm not saying it's not important, but it cannot be the only controlling factor of innovation analysis. There's actually more to it than the innovation motive being impacted.
Now, I think that you're right on two levels. First of all, there hasn't been enough communication between the business school economists or the business strategy economists and the competition economists. And as a result, we have a very simplistic view of how the management of firms leads to competition. The second thing is that you're absolutely right that looking at incentive is a starting point. But it's only a starting point. We at the OECD, for example, we had two roundtables recently precisely on those topics. First of all, when you look at the relationship, at what concentration does to incentives in terms of innovation, and if you look at the incentive for the merging parties as well as the incentive for the competitors to react or not to react to the incentive to the innovation of the merging parties, you find that there's a very complex array of cases. There's a good Japanese paper that talks about 7 different relationships and they are not all consistent with each other. The second thing is capacity. Absolutely right. And I'm a bit more gentle with the Dow DuPont merger decision because it was the first one where
At least.
there was an attempt to really look at capacity
Very
as an element. Okay. But an attempt, I said.
Yeah.
But unfortunately, there's a third dimension, which is very hard to control, which is management. The quality of the management. You referred earlier to the Boeing McDonnell Douglas merger.
Yeah.
This is an excellent example of a merger where clearly the merging firm had the capacity to innovate and to be a leader on the market. And this was one of the competition concerns expressed by certainly the European Union. And the history as it developed showed that the management turned out to be completely incapable of bringing to the fore those innovation. And in fact, that led to some of the major difficulties that Boeing in. What is very difficult, of course, is to anticipate, because there's no reason why the skills of management or even the nature of management should not change over time. And that is one of the great difficulties of anticipating whether innovations are going to be the result of competition or not.
Yes, this is perfect. Well, with that, I think we can wrap it up. I hope this was interesting for people who dedicated the time into it. Certainly, it was very informative and interesting for me. We share a platform with you quite frequently, and we get to see each other frequently, which is my luck. But still, even with that, I always find out new layers of your ideas about this particular topic and about others. Thank you so very much for dedicating your time to this. I hope it was interesting for people in the audience as well.
And I really encourage people to read your book. It's a very interesting book on an extremely important topic.
Very kind of you. Thank you very much.
You listened to an episode of Antitrust Code by Concurrences. If you want to read more about this topic, check the Concurrences website, where you can find all relevant articles. Follow us on Twitter @CompetitionLaws and join the Concurrences group on LinkedIn to receive updates on our next podcast.